So good morning. Today's session is legal methods. My name is Shazia Khan, and we'll be doing today learning outcome 2, which is to understand the principles of legal interpretation. Now, the last session we did was learning outcome 1. In that session, we looked at the issue around the sources of law. We looked at things like how to cite cases and what actually certain concepts mean. So things like R, do you remember what R means?
Yes, the king, queen.
The king or the queen, yeah, Regina.
Yeah.
Or Rex for the king. We looked at how to cite criminal cases and civil cases and the importance of, the year the case was heard, the place it was heard, like maybe criminal division of the Court of Appeal. We then looked at things like the law reports being quite important. Statutes, so the Human Rights Act we looked at the European Convention on Human Rights. We also looked at the position of judicial offices in the English legal system, like the Lord Chancellor when the Constitutional Reform Act changed. We looked at the Attorney General. We looked at primary sources and secondary sources. So primary sources being legislation, and then secondary sources being things like textbooks and academics' work, and people like Dicey, Moody, Jennings. We also looked at the issue around the separation of powers. We looked at common law and equity, what civil law was opposed to criminal law, different types of civil law, which things like contract, tort, negligence, company. We looked at family law, looked at delegated legislation a little bit, which we'll look at more later on, and the types of delegated legislation. And we looked at the hierarchy and the sources. A snapshot of the hierarchy of the courts, the highest court being the Supreme Court, down to Magistrates' Court and County Courts. We looked at the importance in the stages of lawmaking, how it go through different stages, both in the House of Commons and House of Lords, and then also looked at when a bill becomes a law. So before it goes through them, after it's gone through the stages, it needs to receive royal assent from the Queen or the King to identify that the law is going to be passed and become an act. We looked at the impact of the Human Rights Act, which is really important in regards to the European Convention, and in the UK we have the Human Rights Act. We also looked at the Article 4, which looked at slavery and forced labour. We looked at secondary legislation and separation of powers, the importance of separation of powers, and how the 3 organs of the state, so executive, judiciary, and legislature, and how they work together, but the power is not vested into one single body, because if the power was vested into one body, then there would be a dictatorship, or there would be issues of bias and corruption. So we went into looking at the executive, each one, how they work together, and then we looked at the issue around the importance of separation of powers in today's society. And now we're going to be looking at understanding the legal principles of legal interpretation for learning outcome 2. So again, a recap. So we looked at the types of law. So you've got natural law, you've got positive law, which is political law. You've got national law, constitutional, ordinary law, public law, private law, administrative law, general law, statute law, ordinance, case law, and common law. And constitutional law is based on the Constitution, so it will be based on the UK itself. You've got statute law, which is enacted by the legislative bodies. Administrative law, which is rules and regulations made by administrative agencies. Civil law, as we mentioned in the last session, addresses any sort of wrongs done to individuals by any sort of organization. So in civil law, you are more likely to get some form of compensation. Then we've got criminal law, which addresses wrongs done to society. Procedural law deals with methods of enforcing legal rights and duties. Substantive law defines legal rights and duties, and business law, which looks at business situations and transactions. So the hierarchy of the courts, which we looked at in the last session as well, which you'll have more of an identification of. So if we work from the bottom, the first elements is the lower courts, okay? You'd have the magistrates' courts, and here are trials for most criminal offences, some civil matters, and magistrates here, they have district judges. What kind of cases would be heard in magistrates' court? What do you think would be heard?
In a high court.
A magistrates' court, magistrates, which is the lower court.
Okay. I think the bills or immigration asylum seekers.
Magistrates' court is less like severe cases. So, for example, Ada, if someone pinches something from a shop, maybe steals something from a shop, but if the case is in magistrates' court, they can decide less cases, less severe cases. If the magistrates feel like the case needs to go to the Crown Court because it's more, severe, then it would go by trial and it would go to a jury. Okay, that's where the jury would decide, barristers would be involved, judges would be involved, and recorders would be involved. So this is where the jury would make the decision. Whereas in a magistrate's court, you've got the magistrates that will make the decision. So it's magistrate's court is literally minor cases. Things like, if you're driving without car insurance, things like if you have no MOT, no road tax, and you've been fined. So very severe. And the reasoning behind it is, if you have so many courts, they won't all be bombarded with so many cases. So, the level of the court is the level of the offence that is committed. So then you have the county court, which is trial for most civil cases. You have the circuit judges there, the recorders, the district judges, deputy district judges. And then when we talked about a little bit about family court as well yesterday, didn't we? Which is where they have the high court judges there, circuit judges and recorders, district judges, deputy district judges and magistrates. And that's more of a sensitive area, family courts. So a lot of it is dealt with different to any sort of driving without insurance or anything. Family court is its own court. And the reason behind that is more sensitive. Then you've got the Crown Court, and that is jury trial for all indictable offences and some either way offences. So appeals against conviction and sentence from the magistrates' court. So because the magistrates' court can't deal with it, it goes up to the Crown Court. Okay?
Yeah.
Then they have the High Court. And this is like Chancery bench division, all three divisions, as well as first instance. So that goes to the High Court. Then you have the Court of Appeal, which is appeal on points of law, either criminal or civil. And then it goes to the Supreme Court, which is only on points of law and appeal only. On the other side, you've got the first tier tribunal, appeals from executive agencies, tribunals, judges and members. And on that side, which is this side here, is more tribunal, so that's more immigration and asylum there.
Yeah.
So they don't really go through the magistrates' court or the Crown Court or anything like that. They go through a tribunal, okay? And that's things like, if there's a first tier and then there's an upper tier, so that's appeals. So that could be if someone's appealing their asylum claim, they would go to the upper tier. The next one is the Employment Tribunal, and that would deal with claims of matters of employment. So that could be things like discrimination. It could be, so where someone's been sacked because of their job, because of their disability. So it could be anything to do with that. Then you've got the Employment appeal tribunal, and that's appeal judges and members. So, you know, why do you think we have so many courts, and why do you think, Ada, there's a need to have so many courts?
Because it depends the case,
Yeah,
the
yeah,
judge,
yeah.
yeah, and
Does it depend on, you know, the whole point about this is you don't want one court to have so many cases that it takes years to deal with.
yeah,
Yeah. So to spread it out, it gives each court its own kind of role and jurisdiction to play, because then the other court may be busy. So, you know, this kind of hierarchy works really well in the UK.
yeah.
Okay. So that's the court system, and the tribunal's chart structure is here. So when we have the first tier, we'll go from the lower. You can have tribunals in war pensions and armed forces. You can have tribunals in social employment. You can have tribunals in health education. So if someone maybe, you know, is appealing against a school for the child, they may have to go through this process. General chambers, tax. You could have it for immigration, like we said, immigration and asylum tribunal, property tribunal, employment tribunal. They would go then to the upper house, to upper tribunal, which looks at administrative appeals. And you've got upper tribunal, tax and chancery, and then you've got immigration and asylum tribunal. And then you've got the final one, which is land tribunal, but then you've got the appeal tribunal, and they're all upper tribunal. They do then go to the Court of Appeal or Court of Session if there is a need to go higher up. Now, every time there's a need to go higher up, it's not free. Do you know what I mean? So you don't always get legal aid for these cases. You have to pay privately. You know, I mean, you may have heard from some immigration cases where people have to, you know, they don't have any money, but they still have to pay.
in
Uh,
immigration as well.
Immigration and asylum, yeah, both these immigration cases are very expensive at the moment. You know, you're having to pay so much to appeal a decision of the courts.
Yeah,
You know, it might be an immigration is different to asylum. So immigration is if you want to call your spouse over, or, you know, your family as a visitor. Asylum is part of the United Nations Declaration.
yeah.
And,
But it's
you know, even with asylum cases, when I dealt with asylum cases, when it was when you appealed, after appeal, if you wanted to go to judicial review or to a tribunal, you'd have to pay privately. And people that asylum seekers don't have that money. That's why there's loads of people that overstay and, you know, are in hiding and things like that.
okay. It's a private or legal aid.
No, when you come into the country, you can get legal aid up till your appeal. Okay. Once
Yeah,
your appeal is finished, then some companies don't give you legal aid to carry on. They will only give you legal aid maybe if they think your case is strong.
yeah.
But sometimes it's very, very hard to get in asylum and immigration cases to get legal aid.
Understand.
So people, if they come from a different country, they don't have the money, do they?
Yeah,
So
yeah,
they
of
leave
course,
it.
asylum. Yeah.
What's that, Ada?
I said, of course, they are
Yes,
asylum. Yeah,
yeah.
asylum
But
seeker.
but but because these people don't have the money, the government won't support them and give them legal aid. So these people then, you know, going to overstay and hide and, you know, work and things like that because they don't have any money, they don't have any support. Because
Yes,
everything finishes at appeal stage, everything finishes after appeal.
yes,
So it becomes very hard, and the only people that can really help these people is like churches and food banks, you know, give them some food and things like that.
yeah,
But it's very hard, you know, for asylum seekers, because some people, when they have children, it's difficult. It's difficult, very difficult,
yeah,
because um I used to deal with cases, but I know people that used to come to the country but were very educated in their own country, but they said they were living like animals in this country.
Gosh.
Yeah, so it's very hard. I knew people that were doctors, paramedics, but they said they want to go back to their own country because this country is not treating them well. But also, if you have children, it's very hard to
Yes,
get any
it is.
support in this country.
Yes, it is
So,
hard.
when you go through the system of asylum, it ends at the appeal stage then. And now legal aid, there's not much areas of law that get legal aid. It's very hard to get legal aid.
Yes.
Okay, so that's the tribunal's court structure. So key terminology, we're going to look at what stare decisis is, and it's a Latin phrase that means to stand by things decided. So in short, it is the doctrine of precedent. So here courts will cite stare decisis when an issue has been previously brought to the court and a ruling already issued. So the legal principle of determining points in litigation according to precedent. So what's the difference between precedent and stare decisis? So the past decisions that we rely on as a court are called precedent. And these are past cases. Okay, so like we said yesterday, they may be very similar to the new case. So that's why courts rely on it. Precedent is a legal principle of rule that is created by the court. The decision becomes an example or authority for judges deciding similar cases later on. Stare decisis is the doctrine that obligates courts to look to precedent when making their decision. So, the whole point is when a judge is making a decision, they will rely on, old cases as well, because if them cases are similar to this case that they are dealing with, then, they will make a decision based on that, and they need to refer to previous precedent. The decision or judgment of a judge may fall into two parts: the ratio decidendi, which is reason for the decision, and obiter dictum, which is something said by way. So ratio decidendi is the rule of law on which a judicial decision is based. And then when a judge delivers judgment in a case, he outlines the facts when he finds have been proved on the evidence. Then he applies the law to those facts and arrives at a decision for which he gives the reason. So his ratio decidendi is why he's given that reason. So, he'll deliver his judgment, he'll provide all the evidence, go through everything, and then he'll tell you at the end why he's maybe given you 5 years, 6 years, he'll give you the reason behind it. Then that means ratio decidendi. Then you've got obiter dictum, and this is a judge's expression of opinion uttered in court or in a written judgment, but not essential to the decision and therefore not legally binding as a precedent. It refers to a judge's comments or observation in passing or on a matter arising in a case before he or she, which does not require decision. Okay, then you've got per curiam. Per incurium, literally translated as through lack of care, is a device within the common law system of judicial precedent. A finding of per incurium means that a previous court judgment has failed to pay attention to relevant provision or precedents. So per incurium means that, through lack of care, the last court that made the decision failed to look at all the precedent and all the cases and come to the decision. So they needed to take in the previous cases, precedent and the decisions, but they didn't. Okay, and this is called per incurium. 2.1, explain the doctrine of judicial precedent. So the doctrine of judicial precedent involves an application of the principle of stare decisis, which means to stand by the decided. In practice, this means that the inferior courts are bound to apply the legal principles set down by superior courts in earlier cases. So this provides consistency and predictability in the law. So what do you think this means? So the lower courts, does this mean that the lower courts have to listen to what the higher courts have said?
Yeah, I think so.
Yeah. So inferior courts mean the lower courts, yeah? And then
Yes.
superior courts mean the higher courts. So for the lower courts must take into account what the higher courts have decided, and they because this actually, if you use this principle and this hierarchy that the lower courts are bound by the higher courts, then they have to take into account what the higher courts say.
Yes.
And it's a right way if you think about it. Only if there's an error of law or the judges made a mistake will it go to the higher court. Judicial precedent means that the process whereby judges follow previously decided cases where the facts are similar. Okay, so then they would follow it. The hierarchy of the courts, which we looked a little bit at earlier as well. So magistrates, county, family, Crown, High Court, Court of Appeal, UK, Supreme Court. And then you've got the Employment Tribunal, England and Wales. Then you've got the first tier and the upper tier. And that would deal with more with the immigration side of it. Now, the European Court of Justice, because we're out of Brexit, we're not in Brexit, there's still some cases that go through this, okay? So under Section 3, subsection 1 of the European Communities Act 1972, decisions of the European Court of Justice are binding in matters of community law on all courts up to and including the House of Lords. The House of Lords is the highest court in the land unless a matter of European community is involved. The House of Lords was bound by its own previous decisions until 1966, when Lord Gardner, Lord Justice, announced a change of practice in the practice statement in 1966, where he stated that although the House of Lords would treat its decision as normally binding, it would depart from these when it appeared right to do so. The power has been sparingly. A decision of the House of Lords binds all lower courts. The Court of Appeal, Civil Division. The Court of Appeal is bound by decisions of the House of Lords, even if it considers them to be wrong. Okay, so any decision that the House of Lords or the Supreme Court makes, the Court of Appeal is bound by it because it's a higher court. Okay, so in the case of Young and British Aeroplane Company Limited, 1944, the Court of Appeal held that it was bound by its own previous decision, subject to the following 3 exemptions. So firstly, where its own previous decision conflicts, the Court of Appeal must decide which to follow and which to reject. The Court of Appeal must refuse to follow a decision of its own which cannot stand with the decision of the House of Lords, even though its decision was not being expressly overruled by the House of Lords. The Court of Appeal need not follow a decision of its own if satisfied that it has been given per incurium. So this is like literally by carelessness or a mistake. And decisions of the Court of Appeal itself are binding on the High Court and the county courts. So the Court of Appeal, Criminal Division. In principle, there's no difference in the application of stare decisis in the civil and criminal divisions of the Court of Appeal. In practice, however, in addition to the Young exceptions, because a person's liberty may be at stake, precedent is not always followed as rigidly in the criminal division. In R and Taylor 1950, the Court of Appeal held that in questions involving the liberty of the subject, if a full court considered that the law was either being misapplied or misunderstood, then it must reconsider the earlier decision. So, if there's any issues around, any sort of laws, errors of law, do you think that happens though? Do you think judges are perfect? Do you think they make errors?
Yeah, I think they're perfect, and
Or do you think they're perfect? Do you not think judges make errors? Because they're human beings, we all make, and we all make errors, and we all, may say things that are wrong.
I don't know.
Sometimes judges do make wrong decisions. There's been cases where people have been sentenced in this country wrongfully. And judges have made that decision wrongfully, So, it's easy to identify that the judge.
They follow the evidence.
Yeah,
and
they follow the evidence, but are they always right? What do you think? Do you think they're always
they,
right?
of course, they're human. They made a mistake, but I think they in a right way.
Yeah.
But sometimes, yeah, it's happened. It's
Yeah, it
happened.
happens, yeah. We're
Yeah,
human beings at the end of the day and
yeah,
we do make mistakes,
yes,
yes.
yeah,
So, you know, sometimes they may you know, maybe pass some evidence, you know, they may have not looked at it properly. They may have, you know, not made a decision properly. So, you know, in them instances, you know, courts need to, the higher courts will reconsider the earlier decision. If there's been an error of law or the law has been applied, misapplied in certain cases. And I will tell you, Ada, in the UK, there has been lots of instances. And the big thing at the moment is the postmaster scandal, where people were sentenced wrongfully for not doing anything. And now it's come out 20 years later.
oh,
Yes, and the courts will have to, because they made that decision, they will have to pay them compensation because their lives have been destroyed, them people.
okay.
Have a look at it. It's called the post office cases. They've just come out recently.
Mm,
And it's quite astonishing how people have been sentenced for no reason because their lives have all changed. Once you go to court and once you know, you're sentenced, you know, you know, your life changes.
yeah,
The next one is the High Court. So the High Court is bound up by the Court of Appeal and the House of Lords, but is not bound by any other High Court decisions. However, there are strong persuasive authority in the High Court and they're usually followed. Decisions of individual High Court judges are binding on county courts. A divisional court is bound by the House of Lords and the Court of Appeal and normally follows a previous decision of another divisional court, but may depart from it if it believes that the previous decision was wrong, as in the case of R and Greater Manchester Coroner ex parte Tal 1985. The Crown Courts. So decisions made on points of law by judges sitting at the Crown Court are not binding, though they are persuasive authority. Therefore, there is no obligation on other Crown Court judges to follow them. County courts and magistrates' court, the decisions of these courts are not binding. They're really important in law and not usually reported in law reports because they are lower courts. 2.2. Distinguish between binding and non-binding and persuasive decisions. So difference between binding and persuasive precedent is number one, it binds judges that make future decision. Number two, it's binding precedent must be followed. Number three is persuasive precedent may be influenced with the judge but not be disregarded. Number four, binding or persuasive depends on the place of the court, which the decision is made, the hierarchy. Ratio decidendi, so it's binding legal principle based on material facts of the case. And obiter dicta, plural dicta, statement of the legal principle based on hypothetical facts, not before the court.
excuse
And it
me.
might be
Yeah,
highly
sorry,
persuasive.
sorry.
Is
I don't understand the number 6.
Number 6, obiter dicta, so statement of legal principle based on hypothetical facts not before the court. So any facts that are not put before the courts have not been taken into account. So, you know, they need to, any sort of facts that are hypothetical, which means that are previous, have not been taken into account. Okay, which they need to. And then you have might be highly persuasive. So on later courts, when those facts come from respected superior judges. So this is when the higher courts would take into account, you know, superior judges' decisions. So before we go on to, let me just have a look at the next slide. Let's just, I just want to show you a video. Okay, so I'll stop sharing this. And then I'll put this video on for you. So that, and the video just looks at the IA. So we've looked at the video now on the different court system and what each court does and the reasoning behind what each court does and how cases are dealt with in each court. And the reason is that you don't want the reason behind having so many courts is that we don't want to be inundated with so many cases, and then each court can deal with its own specialist area. So a binding precedent is decided when a decided case which a court must follow, but a previous case is only binding on the later case if the legal principle involved is the same and the facts are still similar. So distinguish a case on its facts or point of law involved is a device used by judges, usually in order to avoid the consequences of an earlier inconvenient decision, which is strict practice binding on them. Overruling. So a higher court can overrule a decision made in an earlier case by a lower court. So the Court of Appeal can overrule an earlier decision of the High Court. Overruling can occur if the previous court did not correctly apply the law. So you can't just overrule. Do you understand, Ada? And, you know, you need to take into account that the lower court has not made the decision correctly and they haven't applied the law. So, you know, that's quite fair. Do you think that's quite fair that if the higher courts think that the lower courts have made an error of law, they're able to overrule the decision?
I've got no idea.
So do you think the higher court, we give that authority for them to change the decision? Do you think that's a good thing?
Yeah, because I think
Yeah.
it's good things, yeah.
It's good because, you know, the decision may be wrong, you
Yes.
know.
Yeah.
Yeah, and then you are there to, you know, help the person and not give, you know, a sentence that is wrong. So reversing the overturning or appeal on higher court, the decision of the court below that hearing the appeal court will then substitute its own decision. Per incurium. A decision which is reached by per incurium is one reached by carelessness or mistake and can be avoided. In the case of Morrell and Wakeling, 1955, Lord Evershed stated that the only case in which decisions should be held to have been given per incurium are those decisions given in ignorance or forgetfulness of some inconsistent statutory provision or of some authority binding on the court concerned. However, this rule does not permit the Court of Appeal to ignore decisions of the House of Lords. So, you know, this is where decisions have been made carelessly or unforgottedly. You know, they have not made decisions properly. Persuasive precedents. A persuasive precedent is one which is not absolutely binding on a court, but which may be applied. The following are some examples. Decisions of English courts lower in the hierarchy. For example, the House of Lords may follow a Court of Appeal decision, and the Court of Appeal may follow a High Court decision, although not strictly bound to do so. Decisions of the Judicial Committee of the Privy Council, decisions of the courts in Scotland, Ireland, the Commonwealth, especially Australia, Canada, and New Zealand, and the USA. They're usually cited where there's a shortage or total lack of English authority on point, and obiter dicta of English judges. Advantages and disadvantages of precedent. So let's go through the advantages firstly. There's certainty in the law. By looking at existing precedent, which is old cases, it is possible to forecast what a decision will be and plan accordingly. There is also uniformity in the law. Similar cases can be treated in the same way. So if there's a murder case that was done 20 years ago, it could be treated the same as a murder case today. This is important to give the system a sense of justice and to make the system acceptable to the public. Judicial precedent is flexible, so there are a number of ways to avoid precedents, and this enables the system to change and to adapt to new situations. Judicial precedent is practical in nature. It is based on real-life facts, unlike legislation, and judicial precedent is detailed. There's a wealth of cases which we can refer to as judges. There are some disadvantages. So difficulties can arise in deciding what the ratio decidendi is, particularly if there are a number of reasons. There may be a considerable wait for a case to come to court for a point of law to be decided, and cases can easily be distinguished on their facts to avoid following an inconvenient precedent. And another one is there's far too much case law and it's too complex. So there's so much case law out there that we have to rely on. So sometimes that's complex. 2.3, illustrate the operation of literal, golden, and persuasive purposive rules of statutory interpretation. Now, these are some of the rules that courts use to help them make a decision and judges use, okay? So the number of rules developed by the courts to assist with the interpretation of a statute. These are literal rule, golden rule, the mischief rule, and the purposive approach. These rules each take different approaches to interpretation of a statute. Some judges prefer one rule, while other judges prefer another. Some judges also feel that their role is to fill in the gaps and ambiguities in the law, whilst others think it should be left to Parliament as a supreme lawmaking body. So some judges nowadays, Ada, feel like they should be the ones making the law, you know, and Parliament shouldn't. But the main body is Parliament. So judges shouldn't be making the law. They should just be filling in the gaps and following the law and interpreting it. But some judges, you know, the older judges want to make the law. It's very difficult sometimes.
Yeah, but the
As the
rule is, yeah, the rule is not, I'm not understand the rule is the points, the upper point.
these points,
Yes. What's the meaning
these
of
are used
rule?
when we go through each rule, these are used by judges to interpret a statute. Okay, so these, if you look, we'll go through each rule. These are interpretation of a statute. A statute is a law. So the judges will look at any of these rules to help them interpret a law. Okay, different judges have different interpretation of what the law means. For example, if the law says that you are not allowed to go on a device, you know, a device, mobile device,
Yeah,
whilst driving, what could that mean to you?
it's, I think it's a good idea.
No, but if a law says that
Yeah,
you
it's a,
can't go on the mobile device whilst you are driving, what does that mean to you?
so,
Because remember, everyone has a different interpretation. So what does it mean to you that you can't drive and use your mobile phone? Is that what it
no,
means to you?
no,
Okay, to some people, it may be you can't drive and use a device. So what's a device? Could it be a laptop? Could it be an iPad?
navigation or
Could it
maybe,
be, yeah, it could be anything. So different judges interpret it different. Some judges may say it's a mobile phone and that's it. But other judges may say it could be a tablet, it could be a
yeah.
navigation, it could be anything. So,
Oh,
you know, judges shouldn't be making the law. They should only interpret the law and they should use these rules to help them.
understand. Okay.
Yeah, because you know, Ada, there's some judges out there that are quite old judges and they feel like they should be making the law. But the only place that makes the law is Parliament, nobody else. But judges feel like because they are judges, they should be making the law, but they shouldn't.
Yeah, yeah.
Okay, and that's more the older judges. Okay, so
Okay.
we'll go through the literal rule, we'll go through each rule so you have an understanding, okay? Under this rule, the judges consider what the statute actually says rather than what it might mean. So in order to achieve this, the judge will give the words in a statute a literal meaning, their plain, ordinary, everyday meaning, even if the effect of this is to produce what might be considered as an otherwise unjust or undesirable outcome. So the literal rule is what the law is passed, whatever Parliament says as the law, like for example, Article 3 says inhumane, degrading treatment, the judge will look at it as that. They won't move from the words. Do you understand? They will just use the literal rule as what it says. So the literal rule
Yes.
says that the intention of Parliament is best found in the ordinary and natural meaning of the words. As the legislative democratic part of the state, Parliament must take into account, want to effect exactly what it says in law. If judges are permitted to give an obvious or non-literal meaning to the words parliamentary law, then the will of Parliament and thereby its people is being contradicted. Lord Diplock said, where the meaning of statutory words is plain and unambiguous, it is not for the judges to invent fancied ambiguities as an excuse by failing to give effect to its plain meaning because they consider the consequences so would be inexpedient or unjust. Okay, so the literal rule is what the law says, and what, for example, if you use Article 8, yeah, that says a protection of the right of family life and private life. That's what the law says. Okay, that's what it should be used, what the law is written. Okay, then you have the golden rule. Okay, this is a different rule. This rule is a modification of the literal rule. It states that if the literal rule produces absurdity, then the court should look for another meaning of the words that absurd. Do you understand? So if the court feels like Article 8 shouldn't say this, but should say another way, the courts will look at it from another meaning.
Yeah.
You understand? So this rule here, the golden rule, is used quite a lot by judges, because what they do is they look at the law and they say, oh, if it could be used, if we could look at the meaning in a different way to try to prevent this person from going to prison or anything, then we will look at it from a different way. So it gives them that flexibility. Okay, here, in the case of Wensleydale and Gray, the grammatical and ordinary sense of the words is to be adhered to, unless they would lead to some absurdity or some repugnance or inconsistency with the rest of the instrument, in which the case the grammatical and ordinary sense of the words may be modified so as to avoid the absurdity and inconsistency, but no farther. The golden rule provides no clear means to the test the existence or extent of absurdity. It seems to depend on the result of each individual case. So each individual case is different. Whilst the golden rule has the advantage of avoiding absurdity, it therefore has the disadvantage that no test exists to determine what is absurdity. Then we have the mischief rule, which is the third rule. This third rule gives a judge more discretion than either the literal or the golden rule. The rule requires the judge to look to what the law was before the statute was passed in order to discover what the gap or mischief the statute was intended to cover. The court is then required to interpret the statute in such a way to ensure the gap is covered. The rule is contained in the Hayden's case, 1584, where it said that for the true interpretation of a statute, 4 things should be considered. Firstly, what was the common law before the making of the Act? What was the mischief and defect for which the common law did not provide? What remedy Parliament hath resolved and appointed to cure the disease of Commonwealth? And the true reason of remedy, and then the office of judges is to make such construction as to shall suppress the mischief and advance the remedy. This rule gives the court's justification for going behind the actual wording of the statute in order to consider the problem that the particular statute was aimed at remedying. So this looks at before the statute was passed. We've got the purposive approach. So this approach was emerged in more recent times. Here, the court is not just looking to see where the gaps are in the old law, it is making a decision as to what they felt Parliament meant to achieve. And Lord Deddick in the Court of Appeal stated in the case of Magor and St Mellons Roller District Council 1950, we sit here to find out the intention of Parliament and of ministers and carry it out. And we do this better by filling in the gaps and making sense of the enactment by opening it up to destructive analysis. This attitude was criticised on appeal by the House of Lords. Lord Simons called this approach a naked upsertion to the legislative function under the thin disguise of interpretation. He went on to say that if a gap is disclosed, that remedy lies in the amending act. These comments highlight one issue with the purposive approach: how Parliament's intentions can be determined and whether judges should really be refusing to follow the clear words of Parliament. The purposive approach is one used by continental European countries when interpreting their own legislation. It's also the approach which has been taken by the European Court of Justice in interpreting the law. So what they're saying is that in the UK, they should be just following what the Parliament has passed as the law. Since the UK became a member of the European Community in 1973, the influence of the UK preference for the purposes approach has affected English courts in a number of ways. Firstly, the courts are required to accept that from 1973, the purposive approach has to be used when deciding on EU matters. Now, because we're not part of the EU anymore, this approach is not widely used anymore. So, you know, because we opted out and we're no longer part of the EU, the purposive approach is used by the European courts, but obviously not by the UK courts as much. Presumptions. So when determining the meaning of a particular words, the courts make certain presumptions about the law. If the statute clearly states that the opposite, then a presumption will not apply, and it's said that the presumption is rebutted. The main presumptions are the presumption against change in common law. So it's assumed that common law will apply unless Parliament has made it plain in the Act and the common law has been altered. Number two, a presumption that means mens rea, so that means guilty mind is a criminal case. Mens rea is one of the elements that has to be proved for a successful criminal prosecution. There's a common law rule that no one can be convicted of a crime unless it's shown that they had the intention to commit it. So if you, for example, want to commit a crime, Ada, you must have an intention. What is intention?
In a criminal
What do you think intention? Sorry?
in a criminal cases.
Yeah, in criminal cases, if you have an intention, does that mean you wanted to commit the crime?
Yeah.
Yes,
You've got
yeah.
a plan
You
for
planned it.
yeah.
Yeah, plan. You know, sometimes you can't, you have to have the guilty mind, which means that you
Yeah.
must have planned
Yes.
the act that you are going to. A presumption that the Crown is not by any statute unless the statute expressly says so. And then number four, a presumption that a statute does not apply retrospectively, so no statute will apply to past happenings. So each statute will normally only apply from the date it comes into effect. This is, however, only a presumption, and Parliament can choose to pass a statute with retrospective effect. This must be, however, expressly stated in statutes. For example, the 1965 War Crime Act and the 1991 War Crimes Act and 1976 Adoption Act. 2M1, determine the ratio decidendi obiter dicta from a given legal case. So you need to research from sites and take up cases to determine whether it's ratio decidendi or obiter dicta. And the cases for ratio decidendi, the famous case, do you remember the one we talked about, the snail in the bottle case? There was a snail in a bottle.
Yes.
And that looked at duty of care, yes. So that's a really important case. You can link onto this and it'll take you straight to the case. And it was otherwise known as the snail in the bottle case. And that's where there was ratio decidendi in that case. And then obiter dicta was in the case of Aaron Ho and Bannister and AMT Futures Limited, Mazilia and Dr. Major and Dr. Gunter. And the Camden London Borough Council. And if you wanted to look at Ada at these cases, you could just link on that, you know, when you go onto the slides, and they'll take you straight to the case. Let me see if that will take you straight to Donoghue and Stevenson, so we know. Yes, look, it's taken you there, straight to Donoghue and Stevenson.
Hello, can you hear me?
And it actually gives you the ratio decidendi of the case and tells you the principles around the case. Okay?
Yeah, sorry, my internet was. Can you hear me now? Hello?
Can you hear me now?
Yes.
Oh, I think the internet just went a bit.
Yeah.
Okay, so can you hear me now, Ada? Yeah?
Yes. Yeah, I can hear you.
Yes. I think it was just the internet playing up. So you've got the cases there you can link on. How to find a ratio decidendi or obiter case. So look at the subject outline, reading list or case list. Read the head note. Read the whole case. Focus on the key facts and arguments and dealing with multiple judgments. How to find an obiter dicta case. Note the relevancy of obiter dicta in future court decisions. Realize that obiter dicta may be different forms. An easy rule of thumb is that obiter dicta ain't the ratio, previous case law, the facts or orders. Spend some time looking for obiter dicta when reviewing a case. Identify the holding or ruling in the court opinion, and isolate all language in the case, both facts and the law, that directs and supports the rule of the case, and consider the remaining language in the case. Its weight may vary depending on whether it's passing a comment or a rule like statement about how the law would apply to a scenario not found on the facts. So, make sure you're looking, if you go to the links with the cases, you could go straight to the cases and it will show you how to, the facts of the case and what was the importance of that case, okay? So
Yeah,
some
okay.
of the references we've used in today's session is Law Teacher, the Judicial System of England and Wales, which looks at the structure of the courts and the tribunal systems, the tribunal organisation. Another website which is really good is the judiciary one, and survivelaw.com, to have a look at understanding certain concepts. Now, when we look at OM and that means the order of merit, and these are some phrases that may come about for you that you could look at. OM is the order of merit, and it recognises the service of the armed forces. Privy Council of the UK is the Privy Council of the United Kingdom, which is a formal body of advisors that advise the government and the House of Commons and the House of Lords. Deputy Lieutenant in the UK is a Deputy Lieutenant and is a Crown appointment and works for the royal family. And then Master of Rolls is an appreciation and an ancient position, devotion, and it is someone who's a judge, who has a judicial position. Okay, have you got any questions now? We've finished learning outcome 2. We've looked at the court structure. We've looked at the different types of literal rules, persuasive rules in some cases, and have a read around it all, because there's quite a lot, for you to digest. So have a read around it before we go on to learning outcome 3, which is next week. Have you got any questions before we finish?
No, thank you. Thanks very much.
No?
Appreciate.
So we've got next. No, it's okay. Don't worry, Ed. It's lovely teaching you. We've got next week, we've got looking at the legal profession. So we're looking at the judiciary, the different types of profession within the UK. We have a judge, we have jury, we have, Crown Prosecution Service. So we'll be looking at that next week, okay? So if you haven't got any questions, we've finished today's session, and then the next session is next week. Is Saturday, Sunday? Yes. And then what you need to do is go on to Moodle. If you have access to Moodle, there may be some additional resources you can look at in regards to trying to look at maybe the different courts or anything. So you've got an idea, and these are some of the links on here are very good for you to go on to help you, try to look at what the meaning of certain words are, and look at cases as well. I would recommend that you do look at, and then go up again, Donahue and Stevenson. I recommend you look at that case because it identifies ratio decidendi, but also looks at the issue around duty of care, how the person owed a duty of care to the person drinking the ginger beer. So maybe have a look around that, okay? If you haven't got any questions, we'll finish now, and then I will see you in the next session, which is next week, learning outcome 3. Is that okay?
Thank you very much. Yeah, everything is clear.
Thank you.
Thank you.
Thank you, Ada. Thank you for
See you
attending
next
today's
week.
session, and I will see you next week. Have a nice week.
Thank you. You too.
Thank you. Bye.
Bye.
We'll do this. See you next week. Bye.